Hello, and welcome to Fieldfisher's Data and Privacy Matters podcast. Today, we're going to give you a roundup of the major legal updates from May. I'm Nuria, a director at Fieldfisher, and I am here with Sophia, and we're both based in Fieldfisher's London Tech and Data team.
Hi Nuria, yes, I'm a solicitor in the team.
Please note that this podcast will be released with an accompanying web page that will provide a hyperlink to each item covered to allow you to take a deeper dive. So in May, we saw one piece of data protection legislation getting older. So happy 6th birthday to the GDPR. And we said goodbye to another that will not see the light, at least for now. With news that the Parliament was going to be dissolved due to the general elections in the UK, this means that the UK Data Protection and Digital Information Bill has been dropped. Any future proposals will depend on the new elected government.
May also saw a major legislative update as the Council of the EU approved the text of the AI Act. So on the 21st of May, the AI Act passed this final vote, and we are now waiting for it to be published in the EU's official journal in the very near future. Once published, the Act will enter into force 20 days later. Although most of the Act won't then apply for another 2 years, some specific provisions do apply earlier, and businesses will need to start assessing their AI following the Act's risk-based approach.
And it's not just the EU that has taken steps to legislate the development and use of AI systems. Colorado state lawmakers passed a landmark artificial intelligence bill on the 8th of May, creating a potential model for other US states as debate continues on how to manage the technology. Senate Bill 205, the proposed Colorado Artificial Intelligence Act, has some similarities to the EU AI Act in that it takes a risk-based approach to AI and establishes rules around high-risk systems, as well as creates requirements for when to disclose the use of AI. So many things have happened in May. Firstly, we're going to turn our attention to the opinion of the European Data Protection Board, the EDPB, on the use of facial recognition technologies.
As we all look forward to flying away on our summer holidays, the EDPB has adopted an opinion on the use of facial recognition by port operators and airline companies for the specific purpose of streamlining the passenger flow at airports. This opinion was requested by the French Data Protection Authority, the CNIL, and considers the compatibility of processing this biometric data with the key principles of the GDPR. The EDPB also considered the compliance of processing using 4 different storage solutions. Now, the EDPB found that the only storage solution that would be compatible with all the principles considered would be if the biometric data was stored in the hands of the individual traveller, such as on a personal device under their control, or in a central database where an encryption key was solely in their hands. These storage solutions would have to be supported by a range of technical and organisational safeguards. And this approach would then balance the intrusiveness of the processing by offering individuals the greatest control.
Does that mean that airport operators and airline companies could use facial recognition technology on any passenger who flies with them?
Not quite, no. The EDPB did say that only passengers who have actively enrolled and consented to participate could have their biometric data processed in this way. So the control will stay with the passengers, and they should be given a real choice to sign up for it or not.
Thank you for that. The same day that the EDPB released its opinion, they also published the report on the work undertaken by the ChatGPT task force. So although investigations are still underway, the EDPB issued preliminary views on certain aspects. With regards to transparency, the report flagged that because ChatGPT collected large amounts of data via web scraping, it is usually not possible to inform each data subject about the circumstances. The Article 14.5b GDPR exemption could apply, as providing data subjects information about the processing would likely be impossible or involve a disproportionate effort. The report also looked at the lawfulness of processing by ChatGPT. The task force found that legitimate interest may be a lawful basis for web scraping carried out to train the large language model, or LLM. Adequate safeguards would change the balancing test in favor of ChatGPT, such as having measures in place to delete or anonymize personal data collected via web scraping before the training stage. Note that these are only preliminary views, and a further report will have to be issued in due course.
Did the report offer any different views for sensitive data?
The report noted that scrape data may contain special categories of personal data, but this does not preclude scraping for training as long as one of the exceptions of Article 9.2 GDPR applies, such as the processing relates to personal data made manifestly public by the data subject.
Thanks, Nuria. We'll monitor the reports from that ChatGPT task force. I'll now turn our legal update spotlight to our UK data protection regulator, the ICO, who were also investigating AI matters. Last year, the ICO opened an investigation into Snap Inc.'s My AI chatbot and issued a preliminary enforcement notice last October after considering that Snap had potentially failed to properly assess the privacy risks posed by its generative AI chatbot. The ICO has now concluded its investigation and noted that Snap had taken significant steps to carry out a more thorough review of My AI's risks, and that Snap had also implemented appropriate mitigations. And although the ICO did give limited information about these mitigations, but it did detail that Snap had undertaken a data protection risk assessment. The ICO warned that this investigation was a warning shot for the industry, and that companies using and developing generative AI must consider data protection from the outset, including mitigating risks to users' rights and freedoms before the product comes to market. And this is a really important reminder of the value and necessity of a DPIA to both document potential risks as well as it acting as a powerful mitigation in the event of a complaint or a regulatory investigation.
Another headline from the ICO this month was their success against the Join the Tribu appeal. Last year, the ICO fined Join the Tribu Limited £130,000 and issued an enforcement notice after the online recruitment firm sent 107 million spam emails to over 437,000 individuals without their consent. Join the Tribu appealed this decision, but this month the tribunal dismissed the appeal. The tribunal highlighted that Join the Tribu's privacy notice was poorly signposted and that sending this number of spam emails without consent was a serious breach of PECA. Join the Tribu now need to provide current consent statements and privacy policies to the tribunal to consider whether it makes its decision on whether the enforcement notice should be upheld. Sophia, let's look back to AI. And I saw that the ICO released their strategic approach to regulating AI. What else has been in the headlines this month?
Yes, that's right. This document sets out the ICO's strategic approach to AI regulation, and it highlights the following areas of focus. So there's foundation models, high-risk AI applications, facial recognition, biometrics, and children and AI. The ICO explains what's on the horizon in terms of future updates of the ICO guidance on AI-related topics, as well as AI-related projects. For instance, some of its sandbox projects, such as a system to help prevent falls in the elderly, or an AI system to help identify individuals at risk of domestic violence. It also explains that the ICO continues to carry out consensual and compulsory audits, and that later in 2024 it will report on findings following a series of engagements with providers of AI recruitment solutions. Otherwise, NIST, the US's National Institute of Standards and Technology, released a draft publication titled AI RMF Generative Profile, based on the AI Risk Management Framework, or RMF, to manage the risk of generative AI. This document aims to help organisations to identify the risks posed by Gen AI and suggests more than 400 risk management actions that AI developers could take to manage these risks. And this practical risk approach does echo the AI Act. But we'll now switch our attention from AI to a cluster of stories about public sector data breaches.
In the UK, the Ministry of Defence hit the headlines after suffering a data breach. Hackers targeted a payroll system used by the MOD and accessed personal HMRC-style information, such as names and bank details relating to up to 270,000 current and past members of the Army, Navy and Air Force. Defense Secretary Grant Shapps reported that the system was reportedly hacked by China. The MOD has taken the affected system offline and is investigated, as is the ICO. We'll follow this story. Last year, the Police Service of Northern Ireland inadvertently published personal information including surname, initials, rank and role for 9,483 serving officers and staff.
Yes, how did this breach happen?
So the information was included in a hidden tab of a spreadsheet that was published online in response of a Freedom of Information request. The ICO has now announced that they intend to fine the police service £750,000. The ICO's investigation have found that the police service internal procedures and sign-off protocols for the safe disclosure of information were inadequate. John Edwards, the UK Information Commissioner, described this breach as the perfect storm of risk and harm, and that this data breach brought tangible fear of threat of life. The £750,000 is a significant reduction on the potential fine to ensure that public money is not diverted from where it is needed. This breach reinforces the human impact of poor data security and the importance of secure internal procedures.
On the subject of breaches and penalties, one headline that grabbed my attention was the 6-year prison sentence for Vastaamo hacker Alex Senturi Kivimaki.
Yes, this was the biggest criminal case in Finnish history in terms of number of victims. Kivimaki hacked the psychotherapy center's patient database and attempted to extort money from both Vastaamo and its patients about 2 years later, threatening to spread the sensitive personal data in the patient files online. He made good of his threat, and after demanding but not receiving €370,000 in Bitcoin from Vastaamo, he published sensitive patient data online. His charges include 9,600 counts of aggravated invasion of privacy related to the dissemination of information, more than 21,300 counts of attempted aggravated extortion, and 20 counts of aggravated blackmail. Factors taken into account for Kivimaki's sentence were the seriousness of the crimes and Kivimaki's own reckless attitude. Last but not least of our big topics this month, I think we should discuss the Dutch DPA's data scraping guidelines.
Yes, definitely. The Dutch DPA, the AP, stated that data scraping, which is when a computer program automatically scrapes data from the internet, is almost always illegal as a breach of the GDPR. Now, this is a marked difference from the EDPB's position in the context of ChatGPT. So the AP was concerned that such scraping would collect a lot of data about a lot of people in a short period of time, and this could include special category data or criminal offence data.
I found it interesting that the AP noted that the only legal basis that might be worthy of consideration is legitimate interest, and consent would be impractical considering the likely volume of data subjects. The AP noted that scraping should never be used for the sole interest of making money, as it would be impossible to meet the conditions of legitimate interest in those circumstances.
And it was really helpful that they gave some practical examples, such as that targeted scraping would be fine, such as if an organisation scraped news websites to find information about its own company. But scraping information from protected social media accounts or private forums would not be allowed.
We'll add a link to the guidelines on the website on our accompanying webpage. It will be interesting to see how other supervisory authorities approach data scraping. But before we finish, are there any other fines or enforcements to note, Sophia?
It's been a very light month on the enforcement side. The ICO issued a reprimand to Birmingham Children's Trust Community Interest after a child protection plan was sent to the family that the plan was produced for. Now, the plan was authorised for the family to view, but it included inappropriate personal data in the form of criminal allegations against a child, which was not relevant to the plan, and that was not authorised for the family to view. The ICO noted that appropriate technical and organisational measures were not in place when the breach occurred, but the ICO did welcome the remedial steps taken by the organisation.
Thanks. Interesting that the ICO chose to issue a reprimand in this case rather than a fine or an enforcement notice. So that's all we have time for this month. Thank you for joining us for this monthly roundup of the key legal updates on the Fieldfisher Data and Privacy Matters podcast. If you have any questions about today's updates, of course, don't hesitate to contact us. And if you found it useful, do make sure you give us a like or review on your podcast channel of choice. And as always, thanks for taking the time to listen. Thanks, Sophia, for joining.